looks, normally whenever we read the newspapers, etc., we keep on coming across there's the mergers and schemes of arrangement. But what is the way forward being a professional as a student? What are the way forwards and what is the overview? So a bird's eye view would be given by Mr. Bhaskar so that young professionals or students of law can understand, and those who are into the profession, I'm also quite sure with the knowledge that Mr. Bhaskar has, that some parts in their mind which actually require certain chiseling would be chiseled, and a better part will come forth to understand this entire gamut of mergers and schemes of arrangements. Over to you, Mr. Bhaskar.
Yes. Thank you, Vikas, and thank you for having me over on a Saturday afternoon. And I'm aware that we are at 1 p.m., perhaps lunchtime for many of the people here. And I hope to make it interesting so that it's either that your Saturday afternoon is made a little worthwhile and we have a productive discussion in relation to mergers and arrangements. I intend to only make it an overview because of the fact that the topic is quite vast, and there is a lot to be discussed on each aspect of these mergers or arrangements. Each of them could be a topic in themselves. And therefore, what I intend to do during the next 45 minutes is to essentially take you through the broad procedural aspects. What is an amalgamation, demerger, or a scheme of arrangement, and what the broad procedures are as contemplated under the Companies Act, and what are the other enactments that get impacted in relation to a merger or an amalgamation. Can I just request the slide to be presented? Possible? Because is somebody sharing the screen? Yeah, if you could just go to the first screen.
Yeah, we are doing that.
Thank you. The concept of amalgamations and arrangements assumes a lot of significance in the corporate arena, for the reason that companies are constantly looking for efficiencies in their business. The efficiencies may arise through combining entities that they have as part of their fold, or through dividing entities which they may have where the efficiencies are kind of locked in, and the efficiencies of one part of the business is masked by the difficulties that another part of the business is facing, and therefore there is a need to unlock the two businesses to allow the profitable business to flourish. Or there are also reasons for where you need to clean up your balance sheet. There are aspects where you need to write off certain investments or capital and other things where you require to undertake a corporate restructuring for the purpose of doing all of those. Now, the schemes of amalgamation or arrangements have always required approval of a court or the NCLT, with the small exception that there is a fast track arrangement in relation to an amalgamation which now need not go to the NCLT. I am not going to stress on that aspect. I'm primarily going to focus on the the standard amalgamations and schemes of arrangements which go through the court process. May I just request you to take the first slide? I broadly divided my topic. Can I just request you to go over to the next slide, please? Yeah. I'm broadly going to speak about what is an amalgamation, what is a scheme of arrangement, what is a compromise. See, section 230 to 240 of the Companies Act primarily deal with schemes of amalgamation, arrangement, and compromises. So these are the expressions used by the Companies Act. So the next slide, please. The first one is, what is a compromise? A compromise is essentially, it presupposes a dispute. And a scheme of compromise is introduced typically by parties where they want to settle the dispute, and for that purpose are taking the consent of the various stakeholders as part of the compromise. For instance, a finance company which is defaulting on its deposits to various deposit holders and to other creditors. It has certain assets, certain monies that are to be paid. It says that I will not be able to pay these monies on the respective dates, but I will pay you 50 paise for every rupee that you owe me over a period of time upon collecting the various receivables I have. And for that, I cannot keep going to every depositor and having a separate arrangement with them, because each deposit is a contract between the depositor and the company. So the company has a method which the Companies Act provides, whereby it can propose a scheme, and it can propose a scheme of compromise with such creditors who are like depositors, banks, and others, where it will go to the court and seek the necessary approvals as part of the process. And upon the court sanctioning such an approval, after the stakeholders have approved it first, then it binds all the stakeholders associated with the company. That is, it includes the creditors, it includes the shareholders, it includes the regulatory authorities as well. And therefore, schemes of compromise have often been used by entities which have shown an intention to repay, have limited resources, have been unable to pay the debts on their respective dates when they are payable, and have therefore resorted to court for the purpose of repayment. Amalgamations, on the other hand, don't necessarily have any compromise. They are usually entered into to combine entities for achieving economies of scale, where two enterprises doing similar businesses are sought to be merged, so that the administration and other activities expenses can be saved. Instead of having it, duplicating it in two companies, you can have it in one. Land is available with respect to one company, which the other company can avail of. And there are various economies of scale which the companies can have for administrative, operational costs, etc., etc. The companies may want to combine with each other, resulting in one surviving company and the other company being dissolved. That's essentially an amalgamation. And the third aspect is an arrangement. Arrangement is essentially everything else, including, say, what is called a demerger. A demerger is where a company splits into multiple avatars. That is, it has on one side a textile business, it has another auto part manufacturing, it has something else. It's all part of one entity. The company may decide that each of us has a destiny of its own. And therefore, the company may decide to split each undertaking into a separate unit and a separate entity. And that splitting of companies into separate entities is called a demerger. And a demerger is one form of a scheme of arrangement. There are other schemes of arrangement where you can reorganize your capital, you can do other things as part of your corporate restructuring, which all fall under the residual head of a scheme of arrangement. So the Companies Act essentially deals under Chapter 15 of the Companies Act with compromises, mergers, and amalgamation stroke arrangements. Now, kindly just go to the next slide. So as I mentioned, the purpose of an amalgamation arrangement is essentially this, that you centralize business operations, you rationalize administrative expenses, operational costs, etc. And for that purpose, the Companies Act has a mechanism, and the legislative framework is broadly contained between sections 230 to 240 of the Companies Act, as well as there is what is called a Companies Compromise Amalgamation and Arrangement Rules 2016 today. So therefore, it is a Companies Act itself, as you are aware, under 2013 Act, is very rule-based, rule-driven, unlike the old Companies Act 1956, which was pretty much a stable act which was there. Now, the act only merely provides for the framework, and the details are all typically contained in rules. And that is the case as far as the amalgamation arrangement, other things are concerned. Now, that is governed by the 2016 rules. And the authority, the quasi-judicial authority before whom we would approach for the purpose of getting the approval for such an amalgamation or a compromise or an arrangement is the NCLT. Next slide, please. Now, there are three stages essentially. We used to call it 2 stages, but I'd like to really break it up as 3 stages. For a normal company which would like to go for any such scheme. See, what is a scheme? A scheme is essentially a contract between the relevant company which is wanting to go for an amalgamation and its shareholders, its creditors, both secured and unsecured, and any other stakeholder who may be affected by such a scheme. So it is essentially a contract. For example, a scheme of amalgamation would essentially contain clauses which deal with the effect of this combination. That is, there would be properties that a transferor company would have, which would be transferred to the transferee company in an amalgamation, where there is a merger. Likewise, in a demerger, there would be a transfer of property from what is called the demerged company into the various units into which it is being transferred, which are called under the Companies Act resulting companies, into which the assets are being transferred. Therefore, there is often a transfer of assets or property and liabilities that go from one company to another as part of any such scheme. These are all matters of contract. And the contract is proposed by the company and approved by the stakeholders ultimately. The stakeholder approval and process I'm going to come to. But that is essentially what it is. The assets are usually transferred, liabilities are transferred, contracts are transferred associated with whatever the business that is being transferred, the employees are transferred, litigation is transferred. So these are typically the aspects or components of what is otherwise require specific approval from each stakeholder. Companies Act provides that in order to facilitate businesses from doing these restructurings, that if there is an overview or an oversight, if there is a common approval granted by stakeholders through meetings, and a judicial authority or a quasi-judicial authority like the court or the NCLT approves it, then that is sufficient to enable the companies to split rather than having the contracts moved, novated in each case to another company where I'm trying to move the businesses to another company. Now that involves 3 processes. First is that there must be a stakeholders meeting convened for which there will be a company application which is filed by the relevant companies which want to enter into this amalgamation. Kindly move to the next stage, next slide please. This stage is the stage where you would identify who the stakeholders are who are going to be affected by the scheme which a company is proposing. That would be the shareholders in the case of an amalgamation. There would also be creditors, both secured and unsecured creditors. And the company would therefore have to apply under the Companies Act for convening meetings of the shareholders and creditors of the companies for the purpose of approving the scheme. The proposal for the scheme has to be approved because it impacts the shareholders as a whole, and it impacts the creditors, because the liability that X company has to pay me will now be paid by Y company. So for that approval process, a meeting of the creditors will be convened, and the creditors as a class will have to approve such a scheme, like the shareholders will have to approve. The majority that is required under the Companies Act is 75% of the votes polled at a meeting by members representing at least a majority of the shareholders or the creditors present. So it is a it's a special majority that is required, where the majority of the members present or the creditors present, as the case may be, voting in favor of the scheme to the extent of at least 75% in value. So that special majority will approve the scheme, and once the scheme is approved, then we go to the next stage. But for that purpose, the Companies Act provides that in large companies, of course, there is no question. For listed companies, you have to convene meetings for getting the scheme approved. But the Companies Act also contemplates that these schemes can be proposed by smaller companies with 5 shareholders, 10 shareholders, or creditors who are having smaller numbers, where there are just 1 or 2 banks who may be the secured creditors, etc. In those kind of cases, it is often the practice that these meetings of shareholders and creditors are often dispensed with. Then the court typically dispenses with the meetings of shareholders when you file the consents of 100% of the shareholders. And as far as creditors are concerned, typically you would apply for secured creditors dispensation also. If all the banks and all the other secured creditors approve of the scheme, you will therefore go to the banker and say, this is the scheme I'm proposing. This is how the liability which I have to repay to you will be repaid going forward. And the banks will give a pre-approval for the scheme because they believe that their security is not compromised, because the assets are also getting transferred to the new company, and the same will be offered as security by the new company back to the bank. So long as the banks are satisfied, they will give a pre-approval, and therefore the dispensation of the secured creditors meeting will also be granted. And the unsecured creditors typically will be trade creditors, therefore they will be larger in number. And unless you have 90% of the approval of the unsecured creditors, typically a meeting is convened of such unsecured creditors. In a creditors meeting, in a shareholders meeting, we are aware that 1 share will usually have 1 vote, and therefore that's how their voting is calculated. In creditors meetings, it is 1 rupee which is outstanding equal to 1 vote. So typically the unsecured creditors meeting basically will again have to approve with the same special majority we mentioned, where 1 rupee is 1 vote, and that will be crystallized on a particular record date for the purpose of determining which creditor has how many votes as of a particular day. And then this will be widely publicized in the form of advertisements that are issued on the directions of the NCLT in an English paper and in a vernacular paper where the company's registered office is located. And we also, what the NCLT will do is to issue notices to the various regulatory authorities who are connected. May I just request you to just go to the next slide. So what we have to file along with the application for the purpose of the court sanctioning the meeting are typically the latest balance sheets, the list of creditors with respect to whom we are asking for a meeting. A statutory auditor will have to confirm that the scheme is in accordance with the Companies Act. So therefore, that also is required to be filed. Next slide, please. So these are all the procedural formalities that you would have to follow for the purpose of getting this first stage, getting past the first stage. Next slide, please. So once the 100% of the shareholders approve the scheme, some NCLTs have said that no, you convene the meeting because there is no power for dispensation, while some of the NCLTs have had a practice of dispensing with the meetings where the shareholders and creditors have unanimously or by a significant majority approved of the scheme without having to, because it will save cost. Otherwise, we'll have to issue an advertisement for convening a meeting, etc. In order to save cost and time, typically companies, smaller companies especially, go for dispensation of meetings on the basis of consent affidavits. Next paragraph. Next page, please. Next slide. Yeah. The court also, simultaneously with the convening of the meeting, also sends notices to various statutory authorities who are connected with the scheme. Who are these authorities? Typically, these authorities are the regional director and the registrar of companies, both forming part of the MCA. The official liquidator in relation where one of the companies is sought to be extinguished in a merger where A company merges into B company, A company loses its existence. So therefore the company is getting dissolved. So they will have an official notice will go to the official liquidator to see if the company's affairs, the merging entity, the affairs are conducted in accordance with law and it is not against public interest. That is, they don't want something to be swept under the carpet through the merger. So therefore, official liquidator notice will go. Notices go to the income tax authority. Then these days, the Competition Commission is also involved because of the fact that mergers beyond a particular threshold and a size require a notice and approval from the CCI also. So larger transactions, they are called combinations in the language of the Competition Act. And therefore, those kind of transactions also require the approval of the Competition Commission. If, however, there are small companies that are merging, you typically file an affidavit saying that you don't meet the thresholds or you fall under one of the exemptions under the Competition Act and the regulations. And therefore, there is no need to issue notice to the Competition Commission. In cases such as NBFCs, mergers involving NBFCs, etc., the Reserve Bank of India also comes into play, where investment companies are involved, where they are what they call core investment companies, etc. Then those kind of cases, the court also issues notice to the Reserve Bank of India, where it is a regulator. Listed companies mergers will also involve notice to Sebi and the stock exchanges also. So these are typically the regulatory authorities to whom the NCLT will issue notice simultaneously to seek their views on whether or not they should sanction this particular scheme, besides the shareholders and creditors approving it. Now let's come to the Competition Commission related approvals in detail. Basically, under the Competition Act, essentially the Commission will overview or supervise and regulate a combination which involves a merger or an amalgamation if they are large transactions. If the Competition Commission believes that such a merger will have an adverse effect on competition itself in the market, where the two companies which are merging operate, then in those kind of cases, they will have a say. So typically what you would do is you would have to give a notice. When the board of directors approve the scheme before it is sent to the NCLT for following this process, within 30 days, one has to give notice to the CCI. And typically there are thresholds. You will give that notice only if you achieve the relevant thresholds under Section 5C of the Competition Act. These thresholds are fairly large thresholds. So really what we are talking about are really large companies which are seeking to do some corporate restructuring as a merger or an amalgamation. Can you go to the next slide? I'll just show you some of the thresholds. So these are all the thresholds which are really relevant from a Competition Act perspective under 5C, where assets are over 2,000 crores, turnover over 6,000 crores. So that kind of work at a group level. So there are various thresholds that are worked out at the individual company level, or if the company belongs to the group. Then they also see what are the assets and turnover of the entire group in question. So only when the thresholds are met that you really have to issue notice to the Competition Commission, and the Competition Commission comes into play. For normal, smaller companies which are going through this corporate restructuring, really the Competition Commission doesn't come into play. Even where in respect of such large companies, there are certain statutory exceptions. Next slide, please. What is called a de minimis exception. That is where, for example, there are two typical exceptions. One is that if the assets that are sought to be transferred, that is the transferor's assets, transfer is such a small company, even though the transfer is a large company, that its assets are not more than 350 crores or the turnover is not beyond a particular amount, then those companies do not have to apply for approval under the Competition Act for a certain period. That's called the de minimis exemption. Similarly, with respect to, there is a schedule in the combination regulations where certain types of transactions amalgamations and mergers don't require the approval, where it is only an internal group restructuring. For example, a subsidiary is merging with a parent company. That's purely internal. There is no effect on competition, etc. So there are statutorily recognized exemptions which on the basis of which you don't have to issue that notice under Section 6(2) of the Competition Act. So these are all the typical things which you bear in mind while deciding whether or not, when I'm doing a scheme, I look at the size of the companies which are involved in the scheme, see whether the thresholds are met. If the thresholds are not met, then I don't have to issue a notice. I file an affidavit. If the thresholds are met, I see if the transferor company is small, see whether the de minimis exemption applies. And if it's a group company merger, then you also see whether the Schedule 1, one of these enumerated exemptions for a group company merger or a holding company, subsidiary company, amalgamation, those kind of things are typically. As far as demergers are concerned, the way demergers are treated is that they are treated like an acquisition of an asset. So under the Competition Act, there are, for any acquisition of assets or business, also you require the approval of the Competition Commission. So a demerger is looked like, even though assets and businesses are moved out of a company into another company, it is viewed analogous to how, as if the other company, which is the resulting company, buying a business from the company which is transferring it. So if the value of those businesses, assets and turnovers are over a particular size, then again we get into all of these thresholds, the asset and turnover thresholds for that, and then whether if the value is less than a particular size which is being moved out, then the de minimis exemption, and then again whether the Schedule 1 applies with respect to the demerger. So this is a checklist kind of a thing which you will have to go through to see if we have to go and get the approval from the Competition Commission in respect of any merger. The next slide, please. Then we come to Sebi. As far as Sebi is concerned, primarily, as you are aware, it is primarily relevant only for listed entities. There are two stages where Sebi comes in. One is that with respect where a listed company is part of a scheme, where, for example, in Infosys is merging one of its subsidiaries into itself. In those kind of cases, or for example, where, after the Satyam scam, a Satyam merged into a Tech Mahindra. So in those kind of cases, the stock exchange, you will have to issue a notice to the stock exchange pursuant to a regulation framed by Sebi called the Listing Obligations and Disclosure Requirements Regulations, called the LODR regulations. Regulation 37 requires the listed companies to file the draft scheme before it even files it before the NCLT and get what is called a no objection letter or an observation letter, where the stock exchange will then confer with Sebi and then issue what is called a no objection stroke observation letter, saying that it has no objection to this listed company engaging in an amalgamation or a merger or a demerger. Next slide. Next slide, please. This meetings of mergers of listed companies will have a I think the slide, at least for me, the slide presentation is gone. But before it comes back, I'll continue. Essentially these schemes in relation to mergers will of listed companies will also also has to follow what is called Regulation 94, where as I said, the stock exchange will forward the schemes to Sebi in a particular format. And there is also a circular which one has to bear in mind. That is 10th March 2017 circular, which applies to schemes involving listed entities. So basically that sets out the framework with respect to what is to be followed with respect to schemes of arrangement which are proposed by listed entities. And that's an important thing. Is it possible, Mr. Vikas, to bring back the slide presentation? Now, with respect to these listed companies, there is a certain set of disclosures that have to be made. When a meeting is convened of the shareholders or creditors, law requires that the meeting notices will contain an explanatory statement which discloses the summary of the scheme, who are the people who are interested in the scheme, who are the people to benefit from the scheme. In some cases, for instance, with respect to listed companies, they may be dealing with promoter entities, where the promoters have a private entity and then there would be an amalgamation with the promoters entity into the main company, etc. In those kind of cases, in order to protect the minority shareholders, Sebi has also prescribed certain safeguards in certain circulars that are issued, where they say that in those kind of schemes, the promoters will not vote. There will be a voting through a postal ballot, and besides the voting through the regular process, there will be a postal ballot voting where there will have to be a majority that has to be approved from the non-promoter shareholder also. So the SEBI also, because it is in charge of the minority investors, they take into account the fact that the promoters should not be allowed, because of their shareholding, allowed to influence the decisions which will affect the minority shareholders. And therefore, in those kind of cases, the minority shareholders are protected by SEBI by preventing the promoters from voting in respect of those mergers where their entities are involved. Now, the chairman, once the scheme is approved, there will be a chairman for every meeting who is appointed, typically a company appointed nominated person, or in some cases, the NCLTs also appoint advocates or other persons to chair the scheme, an independent person to chair the meeting and present a report to the NCLT within a certain period, which is provided under the NCLT rules. Now, once that is done, thank you. You can just go to stage 3. Next slide, please. Next slide. Next slide. It's page 16 of the slide. Next slide. Next one. Yeah. So as far as listed companies, as I was saying, the notice and explanatory statement would have to be issued. Next slide, please. I've just covered this. Also, now let's come to the stage where, so the shareholders will approve, notices will go to the regulatory authorities, and while the shareholders and creditors have approved it, then we come to the next stage of the petition. Now, the next stage of the petition is the company petition. So we'll have to then go back to the court. Those companies will say that I have got the approval of the relevant stakeholders. The statutory authorities to whom the notices have been issued have not raised any significant objections. And where there are objections or observations that are made, those persons will be identified, and a company petition would be filed by the company seeking the approval of the NCLT. The first stage where the NCLT is involved only for the purpose of convening the meetings. At this stage, the NCLT will be involved with the process of scrutinizing the scheme and deciding whether or not the scheme should be approved. So here the NCLT would then once again fix a date for hearing this matter and once again advertise to see if there are any other persons who would like to object to the scheme. And at this stage, notice will also be issued only to those authorities to whom the original notices were issued, but who have had some observation associated with the scheme. So, for example, if the income tax authority says that the scheme is basically nothing but to evade some taxes from being payable, or SEBI has some observation in relation to the scheme. In those kind of cases, the notices, as far as these will be issued to these authorities for the purpose of hearing them and seeing whether they would file any report in relation to that. Similarly, the registrar of companies or the regional director could also file a report, or the official liquidator could file a report in a merger as to whether the transferor company has not complied with certain regulations, etc. So in those cases, the court will fix a date on which it would take up the matter and also issue an advertisement besides the notice to these authorities, where all the objections could be taken up for the purpose of deciding whether or not the scheme should be approved. And then the court, after hearing the scheme, so who can make these objections? So, so the Companies Act 2013 has prescribed some thresholds. Only not earlier there used to be situations where, especially in the case of listed companies, etc., where people holding nominal shares like 10 shares, 20 shares, or a smaller number would deliberately, for the purpose of delaying schemes, etc., file some nominal objections that they are aggrieved with the scheme in some manner, etc. So to obviate that, now some statutory thresholds have been specified, like 10% for shareholders or 5% as far as creditors are concerned, as for the last financial statement. And that you need to have these thresholds for the purpose of raising objections to the scheme at this stage. So therefore, not a single shareholder's ability to object to the schemes, etc., have been taken away, and therefore there is a minimum threshold requirement for the purpose of objecting to the scheme. At the end of the day, the court, while deciding the scheme, will basically not get into the commercial aspects of the scheme. The court will only perform its role like an umpire. It will see if the procedural formalities are followed and whether the objections would in any manner affect the public interest in any manner. And in those kind of cases, the court will, if the court feels that public interest is not affected in any manner by approving the scheme, it's a matter of domestic concern between the company and its shareholders, etc., then the court will proceed to sanction the scheme of amalgamation. And earlier in the old Companies Act 1956, the scheme would not become effective on the date that the approval is granted. It would have to be filed within a particular period with the Registrar of Companies. It would get effective only from that date. Now, under the new Companies Act, the minute the NCLT passes, unless the scheme says otherwise, the scheme becomes effective. And in all these schemes, typically, the scheme would, you can next slide please. The Companies Act, next slide please. Yeah, there is also an interesting provision which deals with dissenting shareholders and how do you deal with them, as well as minority shareholders who can be purchased out. There are, for example, typically in some companies, because of the fact that company may have been listed earlier, there's a small group of shareholders who are left behind in the company when the company has delisted. They don't know how to get rid of those shareholders. Earlier, companies used to follow what is called a selective reduction of capital and try to reduce their capital and pay those shareholders compulsorily a fair value of the shares and reduce the capital. Now, the Companies Act itself has provided for a mechanism in respect, and rules have been framed recently from February 2020 for the purpose of taking out certain minority shareholders through the scheme. And there is a procedural formalities. I'm not getting into those procedures because that is a topic in itself. But broadly, there is a mechanism for compulsorily acquiring shares of certain shareholders through the process of a scheme where such shareholders are either required to be exited for administrative convenience or if they are acting against the interest of the company or for any other reason. So that's the provision under 230, 11 and 12 of the Companies Act. Now kindly, next slide please. Now there are also, with respect to the compromise rules, I think we can go to the next slide also. This is just a little more of detail as to this 230, 11 and 12. I don't want to, I think there are other topics to cover. So the slide presentation has it. So those who want the slide presentation, they can just request Mr. Vikas and he could probably share it. Now, there are other aspects, as I mentioned, that schemes could be done for the purpose of various purposes to achieve certain tax efficiencies, etc. also. For example, a company within the group may be carrying forward losses while another company is making profit. Now, the company might therefore want to ensure that, why pay taxes when if this profits in one company could be set off as against the losses and unabsorbed depreciation in the other, then perhaps there is some tax saving associated with it. Section 79 of the Income Tax Act will have to be borne in mind with respect to setting off of income as against carry forward losses, etc. Subject to that, schemes are also designed for the purpose of taking advantage of tax efficiencies. Also, in the process of an amalgamation, as we are aware, there are transfers of assets that are taking place, and income tax has a concept of capital gain and taxation of such capital gains. Now, therefore, income tax provides, in order to encourage and facilitate these mergers and demergers to take place, certain types of mergers which are statutorily recognized and demergers enjoy an exemption from capital gains. So, if I may just go to the next slide. Amalgamation under the Income Tax Act, if it is carried out, then the assets that are transferred from X company to Y company will not result in a tax consequence. They are tax neutral mergers. So what are the conditions to be followed for an amalgamation in such a case? All the properties of the transferor company before should become the assets of the transfer. You can't cherry pick. Every asset of the transferor company should go and become the property of the transferee company. Then shareholders who are holding at least 75% of the value of the transferor company should become shareholders in the transferee company of a number. That is to ensure that you don't use this as a mechanism whereby you get paid cash at the end of it. It is structured as a merger, but it is really a sale. So really speaking, shareholders at least of 75% should get shares in the other company, and they should participate in the growth and the business of the other company. Next slide. Similarly, demerger has certain conditions. I'm just illustrating it. By no means are these exhaustive, but I'm just broadly illustrating what are these terms and conditions. Demerger again also requires, for it to enjoy the tax exemption, that all the properties and liabilities of the particular undertaking or the business, that is, it should be transferred en masse, and they should be transferred at book value as a going concern. That is, it should be a business that is being transferred. You cannot cherry pick asset. I cannot have a property. I don't want this property. I want to move the property alone to another company. That will not qualify for an income tax demerger. That will attract capital gains under the Income Tax Act. Similarly, the resulting company also issues shares to all the shareholders of the transferor company on a proportionate basis. And there are other similar conditions which are specified. That is, shareholders who are holding at least 75% also become shareholders there in the resulting company, etc. Next slide. So if these conditions are met, then 47(6) and 6(b) provide for certain exemptions from capital gains arising out of the transfer of these assets from some suffering tax on any capital gain that may arise in respect of such transfers. Next slide, please. So these are the other provisions associated with income tax which get impacted. In the hands of the shareholders also, shareholder will lose, for example, of a merger or in a demerger, I am getting another share of a resulting company in the context of a demerger for a share that I am holding in the holding company. That also, certain exemptions are there even in the hands of the shareholders if it is an income tax demerger or an income tax merger. So there are also tax benefits that the shareholder has vis-a-vis the shares that he gets arising out of a merger or a demerger in the event of a scheme. Next slide, please. Now, I'm just also taking you through the impact under the IBC. This Companies Act provisions in relation to mergers, etc., have also now been weaved into the provisions of the Insolvency and Bankruptcy Code. As you're aware, before the Insolvency and Bankruptcy Code, it is the Sikh Industrial Companies Act which dealt with the rehabilitation and restructuring, and where there was a separate provision under Section 18 of the Sikh Industrial Companies Act. Now, a corresponding provision is not there in the IBC, but what the Insolvency and Bankruptcy Code has done is, it has incorporated by a specific provision a methodology where a company that is going into liquidation, there can be a scheme or a compromise proposed in relation to such a company, which can be completed during the course of liquidation also. So the provisions of 230 of the Companies Act will have to be followed in respect of such schemes. Suppose somebody is interested in buying the business of a company in liquidation arising out of the Insolvency and Bankruptcy Code. There is a mechanism whereby the Companies Act provisions of 230 are intended to be followed and should be completed within 90 days of the order of liquidation under the IBC. Next page. So as a matter of practice, the first thing which the liquidator does is attempts to see whether there can be a scheme that of a compromise or amalgamation that can be evolved with anybody who is interested in taking over this business from this company which is going into liquidation, before he attempts to sell the assets and liabilities for the purpose of discharging the liabilities in his role as a liquidator with respect to the company in liquidation. So first step he will do is to attempt this scheme of amalgamation. Also, the persons who are eligible to propose the scheme for the purpose of the IBC are the same people who are otherwise eligible to propose a resolution plan under the code. Certain people are not permitted to present a resolution plan, such as promoters, etc., etc. There are, of course, certain exceptions in relation to promoters of MSME. So all those principles apply even with respect to who can propose a scheme of amalgamation or arrangement for the purpose of taking over the business of a company in liquidation under the IBC. Next slide. Now, I'm just skipping over a slide because they are just going into details, one level of detail in relation to this thing. But now I've just come to stamp duty implication also. This has also been a fairly contentious area in various states because through a court process, assets are being transferred from one company. Sometimes these are valuable assets worth several crores of rupees, which if you regularly transfer would attract stamp duty. So therefore, the issue had arisen as to whether or not stamp duty is payable in respect of properties that are transferred through schemes of amalgamation or demerger or whatever. And there are some states, as you're aware, stamp duty is regulated in different manners. Some states adopt the Indian Stamp Act. Some states have formulated their own state acts. Tamil Nadu, for instance, has adopted the Indian Stamp Act with modifications. Bombay Stamp Act is there. Other states have adopted their own respective stamp acts, which provide for the provisions. In the state of Tamil Nadu, until recently, there is no specific entry which specifically required that stamp duty is payable or that any transfer of these immovable properties through a scheme or conveyance, or there is no specific entry which deals with payment of stamp duty with respect to that. There were other states also like that, such as Delhi, etc., where there was no specific entry, while there were states such as Bombay, Maharashtra, etc., which specifically provided for. Are you able to hear me? Yeah. Bombay, Bombay and Rajasthan, Madhya Pradesh, Andhra Pradesh, and other states which specifically provided for an entry which treated stamp duty as payable with respect to even property transfers taking place through schemes. Over the page, please. So I've just given a list of various states and what they have adopted, which states have their own stamp duty acts, which have adopted basically the Indian Stamp Act with amendments, which have their own Stamp Act, which have basically adopted as is. So this is just a table, a useful table for a ready reckoner for one to look at. And see what is the Stamp Act that one must look at to see whether or not what is the stamp duty payable with respect to the properties that are being transferred. You see here, Tamil Nadu, for instance, did not have an entry, and therefore, until recently, through a circular, they have introduced some stamp duty as payable, even with respect to assets that are transferred through schemes. It is 2% of the immovable property or 0.6% of the shares transferred. I have also provided over the next slide, please. Through a slide, some of the statutes where they have specified, which specifically mention what is the stamp duty that is payable with respect to transfers of property. Next slide. Yeah, so I'm just not going over it. Basically, they are typically a percentage of the value of property or a percentage of the value of the shares transferred. They typically tend to be lower than the normal stamp duty payable in respect of conveyances if this property were transferred. This is to basically encourage such corporate structure, restructuring, etc. Next slide. Now, I'm just skipping over this slide. This is just the Tamil Nadu experience with respect to how recently from 2018 onwards, now because there was no entry, a lot of amalgamations were taking place where properties were being transferred without payment of any stamp duty. The government was feeling that it was losing out on a lot of revenue. Since then, they have come forward with a circular and a set of circulars clarifying the same, which currently provides that a stamp duty of around 2% is payable on the immovable property that is being transferred. Some states require stamp duty to be paid on the value of the entire property, both movable and immovable. Tamil Nadu only requires the stamp duty on the movable property. Kindly go to the next slide, please. This is just by way of illustration. Again, next slide, please. Yeah. Now, I just want to come down out to the last portion, which is certain key judgments that one must know while dealing with schemes of mergers and demergers, etc. And I will also deal with some recent judgments. One is Mihir Mafatlal. I guess this is the locus classicus which everybody would have to read if they are going through filing a scheme for sanction before the courts or the NCLT, which is basically the power of the tribunal to basically approve the scheme. Though it was rendered in the context where these powers were vested with the courts, the principle is the same. Basically, the judgment says that the courts don't get into or second guess the commercial wisdom of the companies in entering into such schemes. They perform the role of an umpire. Their only role is to ensure that the companies follow the rules of the game, and basically they will intervene to ensure that no public interest is affected. Other than that, the courts play a very limited role. They don't get into issues of valuation. See, because of the fact that the exchange ratio for every share of the transferor company, how many shares do you get in the transferee company? That will involve the valuation of the two companies, etc. So in those kind of valuation exercises, the courts say that I will not get into it unless there is something perverse. So all of those issues were decided. What kind of meetings will have to be convened? Basically, they say that each class of stakeholder, there has to be a meeting that is convened. And within the same class, if people are treated differently, then they form a separate class and you will have to convene a meeting of that class. Basically, but you take the risk. So if there is an objection that I have not been separately consulted because I am being treated differently, then you suffer. So basically, it's the company that basically decides when it is approaching the court as to the types or the number of meetings that it will have to convene to obtain the approval of the various stakeholders. So Mihir Mafatlal is a very important case. The next case, which I would like to just draw your attention, is PMP Auto, which is a Bombay High Court decision. Next slide, please. Yeah, this case is relevant for two purposes. One is that objects clause. Sometimes when you are merging companies doing different businesses, you would not necessarily have the object clause of the transferor company in your objects clause. So basically, they say that an approval, you can get that approval for getting those objects also into your scheme through the scheme itself. You don't have to separately first amend your objects clause or amend your articles in any manner so as to accommodate this. You don't have to have a separate object for even amalgamating, because these are all the various objections taken at various points of time that the company did not have as its object the object of merging with some other company. So the courts have said that no. When the court is approving and the shareholders are approving through their special majority, they are also giving approval for all the consequential requirements which would otherwise require the approval of shareholders for giving effect to the scheme. So it's a single window scheme. So PMP Auto is basically an authority for the concept that the approvals are a single window mechanism, and basically it binds all the authorities. Next slide, please. Marshall and Sons is the first judgment, which a Supreme Court judgment rather, which basically said you can have an appointed date. Through schemes, you can basically decide that the assets and liabilities get transferred to the other company from a retrospective date. So that issue came up for question in Marshall and Sons from an income tax perspective. And the court said that yes, it is possible for you to fix a date, an artificial date from which the assets and liabilities will stand transferred once the scheme is approved by the court. So you can go back to the 1st of April of a particular year, for instance, and say that even though the scheme is approved in October of 2020, the scheme will operate from 1st April, on which date the assets and liabilities get transferred. This is usually done to ensure for administrative and other conveniences, because the income tax year also begins from 1st April. And so you don't have to file separate returns mid-year on the part of the transferor company and then after the merger from a transferee company. So it facilitates companies to basically adopt the beginning of the year as the date on which a scheme takes effect. Next slide, please. So Marshall and Sons is an important judgment. I also just draw your attention to a few key judgments. So recent judgments in relation to amalgamations in the year 2019-20. In relation to consent affidavits, this Aloe Vera Tradelink is one case because different NCLTs are following different procedures, whether meetings should be convened or dispensed with, etc. So they say that in this case, even with 90% consent of shareholders, the court were permitted the dispensation of the meetings to avoid the cost of convening the meeting and the time that is taken for that purpose. Next slide, please. Then pipeline infrastructure was a case where the NCLT had first said that the scheme is approved, and then it had directed some additional documents to be prepared for the purpose of transferring the assets. The NCLT said no, the scheme which is attached to the order is the instrument of transfer, and there is no separate document that requires to be assigned. That is the document that requires to be stamped. Next slide, please. This is the DLF case for the purpose of, again, in relation to the concept of dispensation of meetings of creditors and shareholders, where a joint petition was filed in relation to the companies that were involved in relation to the merger or demerger. Next slide, please. Then this is another case, the year 2018, basically dealing with modification of the scheme to extend the long stop date, because the scheme sometimes say that if the scheme is not approved by a particular date, then the scheme lapses. So because of certain unforeseen delays, the parties wanted to extend the date, that long stop date. So the court ultimately permitted that to happen and said that in the context of modification, both under the New Companies Act and Old Companies Act, courts have a very wide latitude and wide discretion. So even though you have filed a scheme, if you find that some change is required after the sanction to implement the scheme, to give it better working, then you can always attempt to modify the scheme by filing an application for such modification. Next slide, please. Then these are some important judgments in the context of the tax consequences of the scheme, because Income Tax Department is also issued notice. Sometimes Income Tax Department comes forward with an objection saying that the scheme is basically a tax evasive device, and therefore the scheme should not be approved. So there, in this case, the appellate tribunal, relying on Vodafone SR case, said that the Income Tax Department can take out separate proceedings for recovery of tax if it feels that it is a tax device, if other company doesn't otherwise fall within the mechanics of the income tax provisions granting exemptions for either an amalgamation or a demerger. You can initiate independent action that doesn't prevent the court from sanctioning the scheme. Next slide, please. Then this is a judgment basically which deals with the valuation in relation to schemes. So they have said that the look by the tribunal into the issue may not be looking into too much of the mathematics of the scheme. They'll only try to basically see broadly whether the interests of the stakeholders are protected. So they won't go into the mechanics of valuation and determine whether a particular methodology has been adopted or not. They'll broadly see whether the valuation is otherwise carried on in accordance with the usual practices and it is not perverse, and nothing more than that. Next slide, please. This is the judgment in relation to stamp duty in the context of the Maharashtra Stamp Act, where there was a specific entry, and that was the judgment, landmark judgment, where they said that this is an instrument of conveyance, and therefore would be liable for stamp duty under the Bombay Stamp Act. An instrument, a scheme through which an immovable property is transferred, is also an instrument of conveyance. So, thank you. Next slide, please. Yeah, so this is broadly an overview of the of what entails a scheme of amalgamation or a demerger or an arrangement when you file it into court, and what are typically the considerations that you bear in mind under the Competition Act, Sebi, income tax, and other provisions. stamp duty, etc. And the key decisions, there's of course, this subject is an ocean. There are, for every scenario, there are precedents that you might find where the courts have been confronted with such situations, and therefore it's literally impossible to cover in greater detail during this period. But I thank Vikas for giving me that opportunity to share my thoughts with you, and I'm looking forward to any interaction, any questions that anybody may have.
We are unmuting Rohit.
Yeah. Hello, sir. This is a real case. In way back in 2018, I bought a share of a company. It's a listed company. It's a very big listed company. The share tanked, and I looked into the books why the shares tanked. I saw that, and during that time, the company was trying to acquire one of its group company, which it was claiming is not its group company. So, the books were fudged to the tune of 2,650 crores, wherein they have shown this profit. And the ultimate purpose was to reverse those profits. And because these profits were used as a stepping stone for stock manipulation, I wrote to the company. When I say I wrote initially, my objections were in form of questions, and then subsequently it became kind of an investigation report running into hundreds and thousands of pages. So for a period of almost 4 months, I wrote to the company on and clearly stating that these are my objections. These are the frauds. You're trying to reverse the frauds, and you have done accounting fraud, stock manipulation, etc. But the company would never reply. Then eventually, after 4 months, I filed a complaint with Sebi. So let's say it was 3rd of January of XYZ year, and the scheme was approved on 21st. But the Sebi did not. Even Sebi or the Bombay Stock Exchange, they did not acted on my complaint, and I was very specific. Why don't you withdraw the no objection certificate given? Nothing was done. No representation was made even before the NCLT. I was there, and because my shareholding was less than 10%, so I could do nothing. I was just standing over there and just watching what was happening. So even subsequently, the Sebi closed my complaints. Then registrar of the companies also didn't acted. He's neither proceeding with the complaints and nor withdrawing the complaints. Meanwhile, because I had done thorough research on the company, I filed further complaints against the company with Sebi, etc., and all those, including valuation, how the valuation were bogus, and most importantly, it was how the accounting was done post the acquisition. So both the demerged company and the resulting company, it was a case of demerger. They have given certificates to the court that we will comply with section 133 accounting standards and all. But the accounting wasn't clear contravention of those standards, whereby the purpose was for resulting company was to boost the net worth, and for the demerged company was to obtain tax gains. So what has happened in case of demerged company, they have credited all the gains to capital reserve account instead of profit loss account. The purpose was to save MAT, but that accounting itself was bogus, being in contravention of accounting standard 24. I even brought this to the notice. Then the valuation was next level of fraud. The demerged company never had any assets. It was a real estate company. So it just had a redevelopment line rights, even in respect of a project which was which has been abandoned by the company 15 years back. So and the purpose of boosting the valuation was so that the debt of the demerged company can be taken by the resulting company, the proceeds of which was swindled by the promoters. Now, I have submitted detailed valuation reports running into hundreds of pages. They kept going into regulation, DCR, everything, and even the registrar is not issuing any notice to the valuer. Sebi has issued notice to the merchant banker. The merchant banker has submitted something which even mathematically is not correct, but Sebi has accepted it and closed the case. So and now I have started receiving, because I've exposed the fraud to the tune of 10,000 crores, and then there's a stock market scam of around 15,000 crores. So now I'm getting threats. So I just want to understand, what can I do? Because I cannot go to NCLT because I don't have 10% shares. I cannot go to a court because 433 bars going to court, and there are a lot of judgments on that. So what is to be done, and how can I even make this registrar do the work? So I have filed RTIs also. Even in RTIs, it has gone to CIC level, and CIC also, was sitting. They just disposed it off in a very shady manner. But they had to provide me the information, but effectively no information was provided. So what can I do in this case?
Yeah, see, it's often the case that when certain provisions are included to cover some broad cases of abuse. There is also collateral damage in the sense that there may be some genuine cases which also get lost, specifically in the context of this 10% and 5%. Earlier, the whole requirement of introducing that thing was on the basis that there were repeated occurrences of uh, uh, small or individual shareholders raising objections in relation to schemes. Which were plain vanilla or otherwise or in order, which were also very time bound. Now, looks like in your case, you have been affected by the minimum threshold requirement that has been specified, and therefore you do not have perhaps a right of audience directly before the NCLT in order to raise your objections to the scheme. Nevertheless, uh, as part of your this thing, you have written to various authorities. For example, the registrar of companies or the regional director or the MCA, which is in charge of ensuring compliance with the provisions of the Companies Act, is an authority before whom small shareholders can write and place their objections. And if they don't act upon it, then the appropriate remedy is a writ remedy of mandamus, for at least for a direction on the part of these people to dispose of your representation as to what steps they have taken vis-a-vis. So your remedy would have been perhaps to file a writ vis-a-vis some of the silence that some of the authorities have shown vis-a-vis your representations. However, with respect to representations which have been rejected, such as the ones that you mentioned vis-a-vis Sebi, etc., there are appellate remedies there. And the fact that the scheme has been sanctioned does not mean that the investor grievance associated with the underlying transaction will be ignored. There is an appellate remedy available with respect to the disposal of that representation by Sebi. So there are certain recourses that are available to you with respect to each of those channels that you have approached, with respect to Sebi, with respect to ROCRD, etc. But unfortunately, as you say, the NCLT perhaps did not give you audience because of the fact that you did not hold sufficient shareholding. And I'm saying that it is not uncommon where companies have attempted to use merger stroke this thing to kind of cover up or abuse this process of this amalgamations and schemes of arrangement to cover up some financial improprieties as well. So that's all I can comment. But
I mean, all my applications with Sebi, they were quite clear that they dispose of their application my application in accordance with the Ashok Dayabhai versus Sebi case, wherein Supreme Court has held that a case cannot be closed without passing an order.
Right.
And all my RTIs also are first paragraph itself is stating the entire judgment, but nothing is happening. Now what is happening is that they are not disposing of my case, so it is showing pending from past 2 years, and I keep on sending reminders. I don't get anything. Obviously RTIs, they are not bothered. So unless and until order is passed, I cannot even go to SAT.
If it's pending for too long, then you attempt to file a writ for a mandamus directing them to dispose of your representation, and that normally the court would pass an order directing the authority to dispose it of within a reasonable period of time. So it won't be kept pending indefinitely in such a case.
Thank you.
Right.
We have unmuted Ifkar. He also wants to
Good
ask.
afternoon, sir.
Good afternoon.
This regarding mergers.
Yeah.
There's mention of horizontal, vertical, and this conglomerate mergers. Could you just give some idea of what is the difference?
No, see, as far as horizontal and vertical are concerned, vertical is down the chain. That is, if a subsidiary is getting merged with a parent company, and you are closing the levels in the corporate organizational structure, then perhaps it is these expressions are more expressions of art rather than a legislative expression. Horizontal perhaps is a merger where entities who are at the same level of the organizational chain are merged with each other for the purpose of achieving certain operational efficiencies, economies of scale, etc. And in order where there are symmetries in merging the two businesses which are sought to be merged together. So basically, these are all names that people give for the purpose of justifying or providing a rationale. Often, both in the application and in the scheme itself, parties provide a rationale for the scheme. And therefore, for the purpose of justifying that rationale, you provide, and these expressions are used for the purpose of telling the court, the NCLT, or the taxman as to why you are doing the scheme and why it is not a mere tax device.
It's the same with conglomerate mergers also, sir.
Yeah, conglomerates are all group company mergers, essentially, within the group, basically to achieve economies of scale.
Okay, sir. Thank you, sir.
So, Mr. Bhaskar, I don't think that we have any other question. And as we had heard about you, that you just speak spot on, and as they say, that strike when the iron is hot, meaning thereby that wherever you had hit the points, the slides are perfect. We will share it on the WhatsApp groups so that they can, those who could not connect it, they can get connected, and those they can further share it with amongst their groups. And I'm quite sure that people would all be benefited from a topic which normally at the first brush, what I said, looks quite complicated. But you, as I said, that you have broken the entire blocks so that it's simplified and everybody can understand. We are, on behalf of all the participants who are watching us live on the Facebook, YouTube, Instagram, and this platform, we are thankful that the way you have shared your knowledge. And friends, since tomorrow is the Dussehra, we have preponed the webinar at 11 a.m. Normally, what we are on a weekend, do it on a 5 p.m. Tomorrow is Life Insurance in India, a bird's eye view by Amber Gupta, Head Legal and Company Secretary of Aditya Birla Sun Life Insurance. So do join us tomorrow before going in a festive mood for the Dussehra at tomorrow at 11 a.m. Thank you, everyone. Stay safe, stay blessed, and